Okay. Now, we will be continuing our discussion. Last time napag-usapan natin ang review sa investigation, and now dito na tayo sa custodial investigation. We were also able to review the different types of evidence last time, no? Before we ended the class. Okay, sige, dito na tayo. So, custodial investigation, from the term custodial, custody. Ibig sabihin, yung iniimbestigahan natin ay nasa kustodiyan na natin. Ibig sabihin, nandun na kasama na natin yung suspect or nasa station na rin siya. This shall include the practice of issuing an invitation. Kaya hindi ko sinabing under arrest siya. Andun lang siya sa station, kasama niya yung suspect. Pero, in-invite mo lang siya. Hindi siya under arrest. So, issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed without prejudice to the liability of the inviting officer for any violation of law. Again, the person you are investigating is your suspect, but he is not under arrest for many reasons. Baka hindi pa sapat yung mga nakuha ninyong ebidensya at kung iba pang kung ano-ano pang ibang dahilan. Pero ang ginawa niyo ay inimbitahan mo siya doon sa estasyon. Sir, pwede po bang sumama kayo sa amin para makapagpaliwanag po sa estasyon? Pwede yung mga ganun. Okay? So, ma'am, paano kung hindi sumama? Pwede ba yon? Pwede, kasi nga hindi naman siya under arrest. In-invite mo lang siya. Di ba hindi naman lahat ng iniimbitahan sumasama? Kahit sa birthday, inibitahan mo yung crush mo, ayaw niyang sumama dahil pangit ka. O yun, wala kang magagawa. Di ba? Okay, custodial rights of a person. Ba't di nag-next? Ayan. So, under Section 12, Article 3 of the 1987 Constitution, ang sabi dyan sa first paragraph, any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent. Kailangan sabihan mo siya na meron siyang karapatang manahimik o hindi magsalita. And to have competent and independent counsel, preferably of his own choice. Dapat sabihin mo rin na pwede siyang kumuha ng abogado niya. Yung gusto niyang abogado. Tama, na gusto niyang abogado. If the person cannot afford the services of the counsel, he must be provided with one. Paano kung wala siyang pambayad sa abogado na gusto niya? Kailangan, requirement ito, bigyan mo siya ng abogado. Ito na yung mga manggagaling sa PAO, yung Public Attorney's Office. He must be provided with one. Okay. So these rights cannot be waived. Hindi pwedeng hindi ibigay doon sa ating suspect except in writing and in the presence of counsel. So, pwede niyang i-waive yun, yung right to remain silent at yung iba pa. Kapag sinulat niya na wini-waive niya yon, na hindi na niya gagamitin yung karapatan niya. And kailangan may presence ng counsel. No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. By the way, etong first paragraph, this is commonly known as the Miranda doctrine. Then dito sa number 2, well, this is obvious. Siyempre, hindi mo pwedeng bugbugin yung tao at paaminin dahil kung may napaamin mo man siya o lahat ng nakuha mong ebidensya mula dun sa pambubugbog mo, hindi mo rin magagamit because of the fruit of the poisonous tree doctrine. Dahil nakuha mo ng illegal yung mga ebidensyang yun. So, hindi pwede. Okay. Paragraph 3, any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence. Okay na, na-explain ko na yan. The number 4, the law shall provide for penal and civil sanctions for violations of this section as well as compensation to and compensation to, and rehabilitation of victims of torture or similar practices and their families. So, pag sinabing penal, this is yung pagkakulong. Pag sinabi namang civil, ito yung daños, perjuicios, pera. Okay. Custodial investigation is any questioning by law enforcement after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. It refers to the investigation conducted by law enforcement immediately after arrest for the commission of an offense. It begins when a person has been arrested and brought to the custody of law enforcers in which suspicion is focused on him in particular and questions are asked from him, the suspect, to elicit admissions or information on the commission of an offense. So, technically, pag sinabi nating custodial investigation, invitation siya. Okay, invitation siya. Hindi pa siya under arrest. Pero kapag under arrest na siya, matutuloy pa rin ang custodial investigation. Okay? So ano ang Miranda doctrine? This means that prior to questioning, during custodial investigation, the person must be warned that he has the right to remain silent, that any statement he gives may be used as evidence against him, and that he has the right to the presence of an attorney either retained or appointed. Ito yun. Yung sa Constitution, Section 12, Paragraph 1. Yung Miranda Doctrine. Pero saan ba galing ang Miranda Doctrine na yan? Kay Miranda. Okay, this is a US case in Miranda versus Arizona, in which the US Supreme Court laid down the principle of custodial rights of an accused. Sabi doon, our holding will be spelled out with some specificity in the pages which follow, but briefly stated, it is this. The prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. By custodial investigation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. As for procedural safeguards to be employed unless other fully effective means are devised to inform accused persons of their right of silence and to assure a continuous opportunity to exercise it, the following measures are required. Prior to the questioning, the person must be warned that he has the right to remain silent. Yun na nga, na pwedeng hindi siya magsalita. That any statement he does may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. Pag sinabing retained, pinili mo. Pag sinabing appointed, ibinigay lang sa'yo. Ito nga yung sa PAW. Nagbibigay lang naman ng abogado kapag hindi mo afford. Pero kung may pera ka naman at may sarili kang abogado, then pwede yun. Pwede mo siyang gamitin. The defendant may waive effectuation of these rights provided the waiver is made voluntarily. Yung sinasabi natin kanina, pwede mong i-waive yung rights na yon, pero kailangan ilalagay mo siya in writing. It should be made voluntarily, knowingly, and intelligently. If, however, he indicates in any manner and at any stage of the process that he wishes to consult with an attorney before speaking, there can be no questioning. Hindi mo pwedeng tanungin yung suspect, hindi ka pwede mag-conduct ng interrogation kapag sinabi niya, gusto ko muna kumausap ng attorney. Okay. Likewise, if the individual is alone and indicates in any manner that he does not wish to be interrogated, the police may not question him. The mere fact that he may have answered some questions or volunteered some statements on his own does not deprive him of the right to refrain from answering any further inquiries until he has consulted with an attorney and thereafter consents to be questioned. For example, binasa mo na yung Miranda Doctrine niya, pero nag-splok pa rin siya. Accepted ba as evidence yung mga sinabi niya? Sige, unmute kayo. Yes, no. Ulit. In-inform mo na siya ng kanyang Miranda rights. May karapatan siyang tumahimik, may karapatan siya kumuha ng abogado na gusto niya. Lahat ng sasabihin niya, magagamit laban sa kanya sa korte. Pero nagsalita pa rin siya ng walang abogado. Pwede ba yon? Accepted ba yon? Yung mga sinabi niya during that time?
Ma'am, yes, ma'am.
Yes, tama. Ma-accept pa rin. Kasi ang requirement lang naman, sabihin mo sa kanya yung rights niya. Kung gusto niyang magsalita, pwede yun. Okay. Paano kung hindi mo binasa yung Miranda Doctrine? Tapos nagsalita siya. Yun, yung pagkakataon na hindi mo magagamit yung mga sinabi niya. So what are the rights of a person during custodial investigation? The right to be informed of his rights. May karapatan siyang malaman yung mga karapatan niya. So the reading of the Miranda Doctrine or custodial rights by the police during his arrest. This carries the correlative obligation on the part of the investigator to explain and contemplate effective communication which results in the subject understanding what is conveyed. Kailangan maipaliwanag nga yun sa kanya. Maipaliwanag sa kanya yung mga karapatan niya, maipaliwanag sa kanya bakit nangyayari yung mga nangyayari nung pagkakataon na yun. Then the right to remain silent and to be reminded that anything he says can and will be used against him. Na pwede siyang hindi magsalita dahil lahat ng sasabihin niya gagamitin o pwedeng magamit laban sa kanya. This refers not only to verbal confessions but also to acts. However, mechanical acts that does not require the use of intelligence, such as providing DNA samples or to answers to general questions, are not protected under this right. Okay? So, pwede kang kumuha ng mga DNA sample. At hindi malalabag yung right to remain silent doon. Then, the right to an attorney or to counsel, preferably of his own choice. If not, one will be provided for him. This right is absolute. Ibig sabihin, hindi pwedeng hindi mangyari. And applies even if the accused himself is a lawyer. The right is more particularly the right to independent and competent counsel. An independent counsel is one not hampered with any conflicts of interest, and a competent counsel is one who is vigilant in protecting the rights of an accused. So may karapatan yung accused na makakuha ng isang competent and independent counsel. Right against torture, force, violence, threat, intimidation, or any other means which vitiate the free will of the person. That's also a right. The right against secret detention places, solitary, incommunicado, or other similar forms of detention. Bawal yon. Any confession or admission obtained from the person arrested in violation of these rights are inadmissible in evidence and cannot be used against said person kapag nilagay mo siya sa solitary. May inamin siya. Hindi mo magagamit yung nakuha mong impormasyon doon. This is called the exclusionary rule. It is excluded from the evidence to be considered by the court during trial. Such confession or admission is tainted and must be suppressed under the fruit of the poisonous tree doctrine. Question. Do rights of a suspect during custodial investigation attach as soon as he is invited to the police station to be investigated in connection with an offense he is suspected to have committed? Yes. Kahit na, di ba nabanggit nga natin, hindi pa naman, nagsistart yan kahit hindi pa under arrest ang isang tao. Kasi pwede mo siyang papuntahin sa estasyon, imbitahan mo siya. So, kahit ba na ganun, hindi siya under arrest, pwedeng maibigay sa kanya yung mga karapatan na nabanggit natin kanina? Yes. The practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed is part of custodial investigation. As such, the rights of a person under Section 12, Article 3 attach. However, the rights of a suspect during custodial investigation do not generally attach to the following situations. First, police lineup or during process of identification. Siguro familiar na kayo sa police lineup, as in may mga taong papipilahin at titignan nung witness. May itatanong yung investigator doon sa witness, then ituturo niya kung sino ba yung tinutukoy. And then, spontaneous statements not elicited through questioning but given in an ordinary manner, spur of the moment statements. Yan, hindi nag-a-attach sa mga ganyang pagkakataon. They are considered as part of res gestae and then volunteered statements. However, the rights of a suspect during custodial investigation, sorry. Lumilipat. Okay. Extrajudicial admission to the prosecutor or a private person, media personnel, or TV interview. Magagamit din yung mga salita doon laban sa suspect. Pero sa pagkakataon na to, the rights of a suspect during custodial investigation do not generally attach. Okay, kapag nagpa-interview ka, may sinabi ka. Investigation made by a citizen or private security officer, hindi rin mabibigay yung rights ng suspect for custodial investigation. It is only when the police investigation is no longer a general inquiry into an unsolved crime, but has begun to focus on the particular suspect who had been taken into custody. It begins when accusatory questions are initiated when a person is taken into custody and deprived of his freedom of action. Okay. Next is tools of criminal investigation. Familiar tayo dito. Tatlong I. Yung first I is information. The general term referring to the knowledge acquired by the investigator from various sources. Related sa information is the intelligence summary, a summary report containing highly significant information that can be used by criminal investigators in planning operations. So, literal na intelligence ito na na-gather ninyo and ginawa siyang report na maikli. Kaya intelligence summary. So that's part of information. There are two classical systems of gathering information. Yeah. French system relies heavily in buying information. Binibili ang impormasyon. English system relies primarily on information given voluntarily. And then, we have interview. The simple and friendly questioning of a person who possesses knowledge that is vital in the investigation process. Usually, ang interview ay binibigay natin sa mga witness, sa mga victims. And then interrogation is the vigorous and aggressive questioning of a suspect. Usually, ito na yung sa suspect natin. May mga pagkakataon na ina-apply din ang interrogation sa mga witness. So, depende sa sitwasyon. Depende rin sa demeanor nung ating witness. So, yan na. Tools of criminal investigation, information, interview, interrogation. So, review lang. Miranda doctrine is a rule or principle in jurisprudence that requires mandatory pre-interrogation warnings. Pre-interrogation warnings. Sabihin, bago ka mag-interrogate, sasabihin mo daw ito. Concerning self-incrimination and the right to legal counsel of the suspect. RA 7438 is an act defining certain rights of persons detained, arrested, and those under custodial investigation. Waiver is a document showing voluntary relinquishment of a right or privilege. Sinabing relinquish inaalis, nawawala. So, yung waiver, isang dokumento na inaalis yung mga karapatan mo or privilege mo. Sinasabi mo, hindi ko na to gusto. Okay? And then we also have instrumentation. The application of instruments and methods of physical sciences to detect and investigate crimes. Also known as criminalistics. Paggamit ng iba't ibang instruments at other physical sciences, applied sciences. Confession versus admission. Anong kaibahan? Sinabi natin confession, this is the declaration of the accused acknowledging his guilt arising from the commission of a crime. Admission, on the other hand, is an acknowledgement of a fact or circumstance without accepting guilt. Guilt may be inferred in admission. When an accused confessed to the commission of a crime, he accepts the facts constituting the offense, but but he, but if he interposes self-defense or other exculpatory grounds, then his acknowledgement is not a confession but admission. Pag sinabing confession, sinasabi mong, opo, ako po ang gumawa ng krimen. You acknowledge the guilt. Pag sinabi namang admission, acknowledgement of a fact. Opo, totoong nangyari ang krimen. Nandoon po ako sa crime scene. That's an admission. Bakit hindi yun confession, ma'am? Hindi naman niya sinabing siya yung gumawa ng krimen. Ano kung nasa crime scene siya? Baka witness siya. Diba? So again, pag sabing confession, acknowledgement of guilt. Admission is the acknowledgement of a fact without accepting guilt. There are two kinds of confession, extrajudicial confession and judicial confession. Sinabing extrajudicial, those made by the suspect during custodial investigation. Simply explained are that those confessions are made outside of the court. Kasi pag sinabi nating judicial, this pertains to court. Di ba nga, merong 3 branches of the government. Isa doon, judiciary. Ito yung korte, yung nag-i-interpret ng batas. Kaya judicial is related to the court. Extrajudicial confession, dahil extra siya, hindi siya part ng original. Parang extra rice, di ba? Ibig sabihin, may rice ka na. Kaso, sumandok ka pa. Kaya umorder ka pa, kaya naging extra rice yun. So, extrajudicial confession is a confession in court, outside court. Okay. While judicial confession, those made by the accused in open court. So, habang ongoing ang trial, may sinabi siyang confession. So, that is a judicial confession. The plea of guilt may be during arraignment or any stage of the proceedings where the accused changes his plea of not guilty to guilty. So, during arraignment pa lang, pag sinabi mong guilty po ako, Your Honor, then that is considered a judicial confession. Okay.